Hey everybody, this one is called Do-It-Yourself Kangaroo Courts number 17, Presumptions. They presume all sorts of crap. First of all, I'm not a liar. Well, I meant a lawyer. No, I meant a liar. You should never take my word for anything. You should always do your own research. I've provided references to aid you in your research, but I don't know everything and I'm open to any ideas. There's four types of people you'll meet in your life. The people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people do not know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? Never forget the men who started this country were marijuana growing, whiskey drinking, tax evading rebels who left their beds at night to shoot at the pigs. All tyranny needs to gain a foothold is for people of good conscience to remain silent. So, to begin things off a little bit here, everybody presumes. In order to defend yourself in these kangaroo courts, you need to know the nature of these presumptions and where they're coming from. So, a presumption of fact is an inference, affirmative or disaffirmative, of the truth or falsehood of any proposition or fact drawn by a process of probable reasoning in the absence of actual certainty of its truth or falsehood, or until such certainty can be ascertained. And a presumption of law is a rule of law that courts and judges shall draw a particular inference from a particular fact or from a particular evidence unless and until the truth of such inference is disproved. A rule which in certain cases either forbids or dispenses with any ulterior inquiry. So they just automatically presume until you defeat their presumption. And it's all taken from color of law. It's all because of the martial law, actually. Color means an appearance, a semblance, a simulacrum as distinguished from that which is real. A prima facie or apparent right, an appearance. Hence, a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise, a pretext. Okay, prima facie. Presumably fit to be assumed as true in advance of conclusive evidence, credibility deduced, fair to suppose, by reasonable supposition or inference, what appears to be entitled to belief without direct evidence. Presume, to assume beforehand. In a technical sense, to believe or accept upon probable evidence, it is not so strong a word as infer, though often used with substantially the same meaning. Prima facie, at first sight, on the first appearance, on the face of it. Presumed, as can be judged from the first disclosure. Presumably, a fact presumed to be true unless disproved by some evidence to the contrary. Prima facie, a fact presumed to be true unless disproved by some evidence to the contrary. Evidence being the operative word, evidence. The code is only prima facie evidence of the laws of the United States. Where an inconsistency between the United States Code and the statutes at large appears, the statutes at large prevail over the code. Okay, that's only one example. Okay, we're going to go through a lot of presumptions in this video. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact, the clerk masquerading as a judge, must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. So they're telling the judge, this is all international law. Okay, you got to understand, this is international law. That's what they're assaulting you with. That's all they ever assault you with. Uniform Commercial Code 3-308. In an action with respect to an instrument, a bond, the authenticity of an authority to make each signature on the instrument are admitted. So they forge your signature onto a bond. That's what they do. Unless specifically denied in the pleadings. If the validity of a signature is denied in the pleadings, the burden of establishing validity is on the person claiming validity, but the signature is presumed to be authentic and authorized. So again, evidence. There's got to be evidence. The following rules apply in an action on a certificated security against the issuer. Now the issuer is you. Unless specifically denied in the pleadings, each signature on the security certificate or an unnecessary endorsement is admitted. If the effectiveness of a signature is put in issue, the burden of establishing effectiveness is on the party claiming under the signature, but the signature is presumed to be genuine or authorized until you defeat it with evidence. Color of law means prima facie, means a contract. Prima facie means presumption. Presumptions are defeated with evidence. Evidence. That's one of the reasons I always put this in my documents. The citation of state or federal statutes, codes, rules, regulations, and court citations with any document created by me is only notice to my public servants that which is applicable to them, and is not intended, nor shall it be construed to mean that I confer, submit to, or have entered into any jurisdiction alluded to thereby. Believe me, I never, that's somebody, you know, that was somebody else's actually that I liked. That's true. Okay, this is all about civil law. Okay, this is all about civil law. All the forms, modes, and proceedings and causes of equity and admiralty and maritime jurisdiction shall be according to the civil law. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action whichever particular nation, commonwealth, or city is established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. This is all municipal law, municipal corporations, territorial, District of Columbia, Downs versus Bidwell. To eliminate all controversies of this character and thus to come with the pivotal contentions which the case involves, let me state and concede the soundness of some principles, referring in doing so in the margin to the authorities by which they are sustained, and making such comment on some of them as may to me appear necessary. Fifth, the Constitution has undoubtedly conferred on Congress the right to create such municipal corporation organizations as it may deem best for all the territories of the United States. Okay, so municipal organizations are only in U.S. territories, folks. They're only in U.S. territories. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. It's because of the martial law. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. Why do you think that judge sits there in that courtroom and says, I can do anything I want in here? Diet versus Turner. That's the non-ratification of the 14th Amendment by Judge A.H. Ellett to the Utah Supreme Court in the case Diet versus Turner. International law rule. State statutes are actually federal statutes adopted for areas under a federal legislative jurisdiction. Federalizes state civil law, including common law. The rule serves to federalize not only statutory but the common law of a state. State and federal venue discuss the civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws, and a cause arising under such laws may be brought in or removed to federal district court under sections 24 28 of the former Judicial Code, now sections 1331 and 1441 of Title 28, District of Columbia Code. They say it's United States Code, but really that's District of Columbia Code. And that's taken from a set of books, or actually it's two books. It's Jurisdiction over Federal Areas Within the States, Report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas Within the States, Part 2, a text of the law of legislative jurisdiction submitted to the Attorney General and transmitted to the President June 1957, and that's taken from pages 158 through 165. So the root of the problem is martial law brings in Roman civil law and displaces law of the land. See the martial laws here video. Martial law is brought in by the bankruptcy. See the bankrupt corporate so-called governments video. Bankster 1, Banksters 2, Banksters 3, de facto courts, and UNIDROIT videos. United Nations is the source of it all. Under Roman civil law, status is everything. Under common law, status is nothing. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. This is the front page of my channel. The subscribe button's already clicked. The bell, the arrow's pointing at the bell hasn't been clicked. You got to click the bell. It'll look like it's vibrating after you click it so that you're notified of uploads. I have exclusive content available on my website and on Patreon. My website has 2 subscription levels. My Patreon channel has 3. And I accept cryptocurrencies. The basic subscription level is $29.99 a year for the videos only, and $49.99 a year for the videos plus unlimited consultations. Now, the unlimited consultations has limits. Because I'm not a liar. Well, I meant an attorney. No, I meant a liar. Because I can tell you what I would do under certain circumstances and where to find the forms. And the only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. So if you want to get a subscription just as a matter of a donation, it's appreciated. It's a modest donation, there's no doubt about it, but a whole bunch of people chipping in a little bit, it adds up pretty fast, and so everything's appreciated. I'm currently publishing 1 video a week. So we're going to talk about 12 presumptions. We already talked about some, okay? And this one is actually taken from, it's from canon law, okay? So there's some more presumptions. And so, and these aren't all of them either. And so, but this, if you understand these, there's ways you can defeat them. And how you do that, and because if you don't, then they're going to sell you down the river. A Roman court does not operate according to any true rule of law, but by presumptions of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact and are therefore said to stand true, or as truth in commerce. There are 12 key presumptions asserted by private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor beneficiary, executor de son tort, incompetence, and guilt. And this is taken from Canon 3228. The presumption of public record is that any matter brought before a lower Roman courts is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter. Unless openly rebuked and rejected by stating clearly the matter is to be on the public record, the matter remains to be a private bar guild matter, completely under private bar guild rules. So again, the way you defeat presumptions is evidence. Okay, so you submit an affidavit. An affidavit is evidence. Presumption 2, the presumption of public service, is that all members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under a public oath. Presumption number 3. The presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to service honestly, impartially, fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. And again, affidavit. The presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith are immune from personal claims of injury and liability unless openly challenged and their oath demanded. The presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates are immune from any personal accountability for their actions. Again, affidavit. The presumptions of summons is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, junior witness, and jurisdiction of the court. Attendance to court is usually invitation by summons unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and position of as the accused in the existence of guilt stands. And again, affidavit. The presumption of custody is that a custom or a summons or warrant for arrest unrebutted stands, and therefore one who attends court is presumed to be a thing and therefore liable to be detained in custody by custodians. This includes a dead legal fiction non-human person that corporate government rules and regulations are written for. Custodians may only lawfully hold custody of property and things, not flesh and blood soul possessing beings, unless this presumption is openly challenged by rejection of summons and or at court. The presumption stands you are a thing and property and therefore lawfully able to be kept in custody by custodians. Affidavit. The presumptions of court of guardians is the presumption that you may be listed as a resident of a ward of a local government area and have listed on your passport the letter P. You are a pauper and therefore under government powers of the government as its agents as a court of guardians, unless this presumption is openly challenged and to demonstrate you are both the general guardian and general executor of the matter before the court. The presumption stands and you are by default a pauper and lunatic and therefore must obey the rules of the court of guardians, court of magistrates court. And there's actually a guy that I know that was successful with the case when he went in there and said, if we can agree that I'm the general executor, then we can proceed. And this is, again, executor is word that is found in the DC Code. Presumption number 8, the presumption of court of trustees, is that the members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending a Roman court, as such courts are always for public trustees by the rules of the guild and the Roman system, unless this presumption is openly challenged to state you are merely visiting by invitation to clear up the matter as you are not a government employee or a public trustee. In this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because you appeared. And again, that's why I file a challenge, a demand to dismiss for failure to state an offense, and that's in the last video about jurisdiction, the 7 elements of jurisdiction, and you go through and prove they don't have jurisdiction, and it's by special appearance. And it's an affidavit, it's by declaration. Presumption number 9. The presumption of government acting in 2 roles as executor and beneficiary is that for the matter at hand, a private bar guild appoint the judge/magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the current matter, unless this presumption is only challenged to demonstrate you are both a general guardian and general executor of the matter before the court. The presumption stands and you are by default the trustee, therefore must obey the rules of the executor and a judge magistrate. Presumption number 10, the presumption of executor de son tort, is the presumption that if the accused does not seek to assert their right as executor and beneficiary over their body, mind, and soul, they are acting as an executor de son tort, or a false executor challenging the rightful judge as executor. Therefore, the judge magistrate assumes the role of true executor and has the right to have you arrested, detained, fined, forced into a psychiatric evaluation, unless this presumption is openly challenged by not only asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor de son tort. The presumption stands, and a judge or magistrate of the private bar guild may seek to assistance of bailiffs or sheriffs to assert their false claim. And presumption number 11. The presumption of incompetence is the presumption that you are at least ignorant of the law and therefore incompetent to present yourself and argue properly. Therefore, the judge, magistrate, executor has the right to have you arrested, detained, fined, forced into a psychiatric evaluation, unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions then it stands by the time of pleading that you are incompetent. Then the judge or magistrate can do what they need to keep you obedient. The presumption of guilt, that's the final one, is the presumption that as it is presumed to be a private business meeting of the bar guild, you are guilty whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth or motion to dismiss with extreme prejudice onto the public record or call a demurrer, then the presumption is you're guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. So check out, I might have exclusive videos. I have and Patreon content, Arlington Private Information Share, Land Deed Training, Estoppel Certificates Training, Foreclosure Estoppel Certificates Training, Corporate Denial Training, Toll Roads Notice and Demand Training, Invoice Training, Notice of Void Judgment Training, Revocation of Signature Training, Third-Party Witness Training, and Federal Habeas Corpus Training. There's also Revocation of Voter Registration Training, Criminal Complaint Training, Lawsuit Training, other training. Northeast Private Information Share videos are also there. All forms, files, and other instructions are available for free on my 2 private groups at Yahoo Groups and Google Groups, and also now on my website. And so all exclusive content is on my website, and you can buy a subscription there. And I also have a Patreon channel. Presumption of money. More presumptions, folks. They're demanding Federal Reserve notes, okay, as Section 15 of the Gold Reserve Act of 1934, located at 48 Stat 337. As used in this act, the term United States means the government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. So then if you think about it, then Federal Reserve notes are meant for internal use of the government only. And so if you use Federal Reserve notes without making some qualifying statement, that's why I put in there that as an extremely less desirable alternative, I can accept the fake money, the Federal Reserve notes, the military script. Presumption of U.S. citizens. A U.S. citizen is not entitled to an Article 3 court, but instead gets an Article 1 court with a plenary military dictatorship jurisdiction, and Article 1, Section 8, Clause 17 of the Constitution of the United States of America, as defined and reinstated in National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, which further states that citizens of the District of Columbia are not embraced by the judicial power under Article 3 of the Constitution of the United States of America. The same statement is held in Hepburn versus Dundas, and in 1804, the Supreme Court, through Chief Justice Marshall, held that a citizen of the District of Columbia is not a citizen of the state. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which the Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's U.S. Supreme Court, 1948. And this is where it's codified. If any citizen or resident of the United States does not reside in, is not found in any of the United States judicial districts, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provisions of this title to A, jurisdiction of the courts, or B, enforcement of summons. And the term individual means a citizen of the United States or alien lawfully admitted for permanent residence. And the term federal personnel means individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. And that means anybody with a Social Security number. And that's Title 5 United States Code, Section 552 AA 13. And Title 5 United States Code is government organizations and employees. The term citizen of the United States is analogous to the term subject in the common law. Residents, as distinguished from citizens, are aliens who are permitted to take up a permanent abode in the country, being bound to the society by reason of their dwelling in it. They are subject to its laws so long as they remain there, and being protected by it, they must defend it. Although they do not enjoy all the rights of citizens, they only have certain privileges which the law or custom gives them. Permanent residents are those who have been given the right of perpetual residence. They are a sort of citizen of a less privileged character and are subject to the society without enjoying all its advantages. Their children succeed to their status, for the right of perpetual residence given them by the state passes to their children. And this is taken from the Law of Nations by Vattel, Book 1, Chapter 19, Section 213, page 87. So again, if you're a resident, then you're a slave. You have no rights. Every taxpayer is assessed K trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. And that's a summary from Henry Bollins, and a summary for 5 pages of congressional record dated June 13, 1967. A citizen of the United States is a civilly dead entity operating as a co-trustee and co-beneficiary of the public charitable trust, the constructive Satanic Trust of US Inc. under the 14th Amendment, which upholds the debt of USA and US Inc. And the DC Code, which was approved on March 3rd, 1901, 31 Stat 1208, where it's 1208, where it says that in addition to the jurisdiction conferred in the preceding section, plenary jurisdiction, that's dictatorship, is hereby given to the said court holding the said special term to hear and determine all questions relative to the execution of any and all wills. And then at 31 Stat 1432, in the DC Code, it says the legal estate to be in necessity use. And further in DC Code 31 Stat 1189, it be it further enacted that in interpretation and construction of said code, the following rules shall be observed, namely, third, the word person shall be held to apply to partnerships and corporations. And fourth, the word executor is used and shall include administrator and vice versa, unless such application. So again, this is where it's all found in the DC Code. Presumption of US citizen, which is a government employee or a Satanic trust. It's impossible to prove jurisdiction exists unless substantial nexus with the state. Absent a substantial nexus with the state, such as a voluntary subscription to a license, all jurisdiction facts supporting claim that supposed jurisdiction exists must appear on the record of the court. And this has been going on forever. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial, okay? And that's taken from the Causes and Necessities for Taking Up Arms, 1775. It's all about martial law. And this is Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for imposing taxes on us without our consent, for depriving us in many cases of the benefit of trial by jury. And this is George III, Chapter 12, 1778. 2 years after the Declaration of Independence, the Imperial Parliament passed this. Whereas taxation by the Parliament of Great Britain for the purpose of raising revenue in His Majesty's colonies, provinces, and plantations in North America has been found by experience to occasion great uneasiness and disorders. Well, no shit, Batman, that from and after the passing of this act, the King and Parliament of Great Britain will not impose any duty, tax, or assessment whatever payable on any of the colonies, provinces, or plantations in North America or the West Indies, except only such duties as may be expedient to impose for the regulation of commerce. That's what I call closing the barn door after the horses get out. The real root of the problem is it's all Satanism. They're getting into one of their so-called contracts, and it's literally a contract with the devil. It's all, the satanic martial law works on presumption. They presume you're in the contract and go ahead and assault you. And if you want any rights, you have to go before one of their bail priests so they can assault you again with their equity in the Roman law. They deliberately screen out intelligent people in their hiring process. They want low intelligence thugs so they can make more business for their bail priests in their so-called courts. The District of Columbia should be called the District of Criminals. Give me liberty or give me death was coined by Patrick Henry after he witnessed a man flogged to death for refusing to take a license. So the Satanists were shoving one of their satanic contracts down somebody's throat. A license is a contract. Is a right given by competent authority to do an act without which such authority would be illegal. The instrument or writing which secures this right is also called a license. The most important thing we can do is stop letting these Satanists divide us so they can conquer us. Most of these satanic statutes are for people who cannot voluntarily respect other people or their property. John Adams said, "Our Constitution is made only for a moral and religious people, is wholly inadequate to the government of any other." And John Winthrop, Speaker of the U.S. House of Representatives, "Men, in a word, must necessarily be controlled either by a power within them or by a power without them, either by the word of God or by the strong arm of man, either by the Bible or by the bayonet." And never ever give up, right? That's what it comes down to sometimes. War is when your government tells you who the enemy is. Revolution is when you figure it out for yourself. The rights of sovereignty extend to all persons and things not privileged. Okay? That's the operative thing, okay? Not privileged, that are within the territory. They extend to all strangers resident therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they are within his territory and owe a temporary allegiance in return for that protection. And that's U.S. Supreme Court. In any action that they bring, always appear by special appearance, file a challenge to jurisdiction into the case as early as possible, take an original and 2 copies to the clerk. The clerk will file stamp all of them and keep the original. 1 copy for you, 1 copy for the prosecutor. Sometimes the clerk will keep the prosecutor's copy, otherwise you need to serve the prosecutor with their copy, and then you make an affidavit of service and file it into the court. In any action, do not bring the document on the day of the hearing unless you don't mind losing. Judges are required to give judicial notice of documents that are file stamped. Okay, if it's not file stamped, you go and hand it to the judge. The judge will probably turn it over, and then he'll be looking at the back with the nothing on it, and he'll say there's nothing here that affects this case. Have a notice of appeal ready to serve on them if they railroad you and enter a plea for you. Have witnesses so you can file judicial complaints. Special appearance is an appearance de ben esse, is designed to permit a party to a proceeding to refuse to submit his person to the jurisdiction of the court unless it is finally determined that he has forever waived that right. Such an appearance is therefore a special appearance designed to allow the accused to meet any supposed requirement of making an appearance, and at the same time to refuse to submit to the jurisdiction of any alleged plaintiff, and therefore of the applicable court, unless and until some judicial department prosecutor makes all disclosures, specifically by producing a complaint of damage or injury, signed and verified by the injured party. Presumption of motor vehicle. Definition: this is the Federal Tax Lien Act of 1966 at Public Law 89-719 at 80 Stat 1130 and 1131. A motor vehicle. The term motor vehicle means a self-propelled vehicle which is registered for highway use under the laws of any state or foreign country. If it's got a state-issued plate on it, then you've got a motor vehicle. Okay, and these low intelligence thugs can presume that you're a government employee. The 2 biggest privileges are Federal Reserve notes and government-owned plates. The privilege replacements is cryptocurrencies and private plates. Consumer goods. This is Texas Business and Commerce Code, which is the same as the Uniform Commercial Code, 9.109, classification of goods. Goods are consumer goods if they're used or bought for use primarily for personal, family, or household purposes, or their equipment if they're used or bought for business, for primarily in business, including farming or a profession. Okay, and so under UCC 9-109, there's a real distinction between good purchase for personal use and those purchased for business use. The 2 are mutually exclusive, and the primary principal use to which the property is put should be considered as determinative. In other words, it's either one or the other. The classification of goods in UCC 9-109 are mutually exclusive. Automobile purchased for the purpose of transporting buyer to and from his place of employment was consumer goods, as defined in UCC 9-109. Thus, self-driven vehicles are classified according to the use to which they are put rather than according to the means by which they are propelled. The provisions of UCC 2-316 of the Maryland UCC do not apply to sales of consumer goods, a term which includes automobiles, whether new or used, that are bought primarily for personal, family, or household use. The Supreme Court in Arthur v. Morgan held that carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. A soldier's personal automobile is part of his household goods. The exemptions provided for in Section 1 of the Motor Vehicle Transportation License Act of 1925 in favor of those who solely transport their own property or employees, or both, and of those who transport no persons or property for hire or compensation by a motor vehicle have been determined in Baker Service Corporation case to be lawful exemptions. In other words, if you have a corporation that has a bus and you're transporting company employees only, then it's not for hire. You're not transporting passengers or property for hire, and so therefore it would be exempt. Consumer goods, automobile for transportation to and from work. The use of a vehicle by its owners for purposes of traveling to and from his employment is a personal as opposed to a business use, as that term is used in UCC 9-109, and the vehicle will be classified as consumer goods rather than equipment. Copies of these documents can be found in my private groups at Yahoo and Google called Administrating-Your-Public-Servants. For a complete set of YouTube videos with private information, shares a DVD with over 50 searchable law dictionaries and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the military script, the fake money, the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders, etc. Send me an email for particulars. Consumer goods are not required to be registered. A vehicle not used for commercial activity is a consumer goods. It is not a type of vehicle required to be registered and use tax paid, of which the tab is evidence of receipt of the tax. In view of this rule, the statutory provision that the supervising officials may exempt such persons when the transportation is not on a commercial basis means that they must exempt them. Consumer goods must be exempted. And this is Texas Constitution, Article 8, Section 1D. The legislature by general law shall exempt from ad valorem taxation household goods not held or used for the production of income and personal effects not held or used for the production of income. And then Texas Transportation Code 502.003, a political subdivision of the state may not require an owner of a motor vehicle to register the vehicle, pay a motor vehicle registration fee, or pay an occupation tax or license fee in connection with the motor vehicle. I like the Texas plates because they can be used anywhere, because all states, Canada and Mexico included, are required to recognize Texas law. This is Transportation Code 501.004. This chapter applies to a motor vehicle owned by the state or a political subdivision of the state. This chapter does not apply to a motor vehicle, that's owned by the United States. So the Certificate of Title Act only applies to government-owned vehicles. And then this is Texas Transportation Code 502.003. We already went over this. A political subdivision of the state may not require an owner of a motor vehicle to register the vehicle, pay a motor vehicle registration fee, or pay an occupation tax or license fee. And so, again, and that's why it's consumer goods. Okay, so then it becomes a felony. If they want to subject you to the deprivation of your right to own consumer goods instead of business equipment, that's a felony. Articles of Confederation, Article 4, Clause 3, the full faith and credit shall be given in each of the states to the records, acts, judicial proceedings of the courts and magistrates of every other state. And so this is the private plates that I have had made up. You can make your own up. There's nothing stopping you from doing that, or you can get them from me. I have them available. But this is the ones that I have made up. This is the one similar to one like this that I use, actually. And I also have these other colors. Depends on what you like. You know, there's some different ideas here that I've made. Anyways, you can get one plate and one probable cause lamination for 3 pieces of silver, 1 troy ounce each, or $50 in military script, Federal Reserve notes, fake money. Before you do this, you need to be prepared to defend it. That's why I have in my car the card in my car, because the discussion should end right there when I show them that nobody's required to register their vehicle. My PayPal is engineerwin@hotmail.com, and you can get Forbidden Zone laminated sheets from catman1@gmail.com. Some of these, the Texas codes, the only ones that would apply in every state are the ones that where you can say that no political subdivision of the state is required to can require you to register your vehicle, and the Certificate of Title Act only applies to government employees. So those ones would be the only ones really that would be useful elsewhere. The rest of them would only be useful inside Texas. But probable cause, before any police officer stops you, they must have probable cause. Article 4 in amendment prohibits law enforcement officers from arresting citizens without probable cause. Arrest made without probable cause violates the Fourth Amendment. Holding involuntary civil confinement is a massive curtailment of liberty, is tantamount to the infringement of being arrested, and can be made only upon probable cause. This is the my laminated sheet, one side of it. The test for the police officer's sufficient basis for probable cause is, did the officer have a sufficient basis to make a practical common sense decision that a fair probability of crime existed? Once the officer's actions fail to satisfy this test, it may appear that no reasonably objective officer could have believed that probable cause existed to make the arrest. And by definition, probable cause to arrest can only exist in relation to criminal conduct. There has to be a crime. Civil disputes cannot give rise to probable cause. If there's no crime, it's a civil dispute. That's the other side of the arrest and probable cause laminated sheet. Perhaps it should be mentioned that as a general rule, a person is placed under arrest when he's deprived of his liberty by an officer who intends to arrest him. It is not necessary for the officer to make a formal declaration of arrest. A motorist stopped by a traffic officer for a traffic offense would be considered arrested, even if the motorist was not specifically informed that he had been arrested. Any restraint, however slight, upon another's liberty to come and go as one pleases constitutes an arrest. An offense, this is again Class C misdemeanors. Okay, an offense for this section is a Class C misdemeanor if the offense for which the actor's appearance is required is punishable by fine only. And so, and that's under Texas Penal Code 3810, bail jumping and failure to appear. So they can only punish bail jumping or failure to appear by fine only. And then classification of misdemeanor. Texas Penal Code, conviction of a Class C misdemeanor does not impose any legal disability or disadvantage. And an individual judged guilty of a Class C misdemeanor shall be punished by fine only, not to exceed $500. So therefore, a Class C misdemeanor is not a crime. If they can only punish a Class C misdemeanor by a crime, then it's by a fine, then it's not a crime. Because a crime means a misdemeanor punishable by jail or a felony. Okay, and that's Texas Government Code 79.001. So if it's not a crime, they don't have probable cause. If it's a Class C misdemeanor, is not a crime. They don't have probable cause. It's false arrest. Texas Transportation Code, failure to pay civil penalty. If a Class C misdemeanor fails to be a crime, then it is by definition a civil matter. If the owner of a motor vehicle fails to timely pay the amount of the civil penalty imposed against the owner, an arrest warrant may not be issued for the owner, and the imposition of the civil penalty may not be recorded on the owner's driving record. So, again, they cannot issue a warrant. In Texas, a police may not arrest you for a Class C misdemeanor, and if they do, it's false arrest. The only thing the plaintiff needs to do is to allege a false arrest, either to one, that the defendant made an arrest or imprisonment, or two, that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. When the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. The burden is upon the defendant to show that the arrest was made by authority of law. If the owner of a motor vehicle fails to pay the civil penalty imposed against the owner, arrest warrant may not be issued. The imposition of a civil penalty may not be recorded. And a capias is not a warrant. In this chapter, a capias means a writ that is issued by a court having jurisdiction of a case after judgment and sentence. So they can't issue a capias until they've held a trial. Capias means a writ issued by a court having jurisdiction of a case after judgment and sentence. And a capias is not a warrant. If a cop stopped me for speeding in Texas, I'd say, I don't have a problem providing whatever you need, but I got a couple questions first. What's your probable cause for stopping me? If he stopped me for speeding, he'll say that. And I'll say, well, speeding's a Class C misdemeanor, and a Class C misdemeanor is not a crime in Texas, and probable cause requires a crime. So I ask you again, what's your probable cause for stopping me, or should I just be on my way? And then I would dial 911, tell them I need the county sheriff, because there's some official oppression going on. And this is Texas Penal Code, abuse of official capacity. A public servant commits an offense if with intent to obtain a benefit or with intent to harm or defraud another, he intentionally or knowingly misuses government property, services, personnel, or any other thing of value belonging to the government that is come into the public servant's custody or possession by virtue of the public servant's office or employment. So if he's stopping you, if he's turning on that emergency light when there's no crime, then that's abuse of official capacity, because there's no emergency. And if he's turning on that emergency light, if he's using that cop car when there's no crime, that's abuse of official capacity. If he's using the radios in the computer system when there's no crime, that's abuse of official capacity. Failure to identify. This is one thing they like to assault you with in Texas. A person commits an offense if he intentionally refuses to give his name, residence, address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. Well, the question is lawfully arrest, okay? If there's no crime, there's no lawful arrest, okay? And if there's no crime, then he's not a peace officer, he's a revenue officer. And so there's two problems here. So again, you don't have any duty to give him anything. Official oppression. A public servant, on color of his office and employment, commits an offense if he intentionally subjects another to mistreatment or arrest, detention, search, seizure, dispossession, assessment, or lien that he knows is unlawful, intentionally denies or impedes another in the exercise or enjoyment of any right, privilege, power, or immunity, knowing his conduct is unlawful. For purposes of this section, a person's public servant acts under color of his office or employment if he acts or purports to act in an official capacity or takes advantage of such actual or purported capacity. And so again, he's wearing that police uniform and he's stopping you for something that's not a crime, then that's abuse, that's official oppression. And then impersonating a public servant. A person commits an offense if he impersonates a public servant with intent to induce another to submit to his pretended official authority, to rely on his pretended official acts, or knowingly purports to exercise any function of a public servant or a public office, including that of a judge in court, and the position or office through which he purports to exercise a function of a public servant or a public office has no lawful existence under the constitutional laws of the state of the United States. And that's a felony under the third degree in Texas. And so then that judge, okay, if the judge is sitting there acting as a judge for the state, or not the state of Texas, just state of Texas, okay, and if you watch my YouTube video about state of Texas doesn't exist, then state of Texas is a it's not a DBA, it's a assumed name for Deer Park Cash Cow LLC. And so when he puts state of Texas up there, then he is really, the real party is Deer Park Cash Cow LLC, and he's saying he's a judge. And so then that's a, and the position or office through which he purports to exercise a function of a public servant or public office has no lawful existence under the constitutional laws of the state, then he's impersonating for sure. And this is conspiracy to violate rights. Remember, it's consumer goods. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise of any right or privilege secured to him by the constitutional laws of the United States, or because of him having so exercised the same, okay, well, think about it. You get 2 or 3 cops that stopped you and are arresting you for your homemade plate, okay, in other words, your consumer goods. So they are injuring you, oppressing you, threatening you, and intimidating you, and you're free to exercise your rights to own consumer goods instead of business equipment. That's a felony. And then they're conspiring to injure, impress, threaten, and intimidate you in the free exercise of your right to own consumer goods instead of business equipment. And whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, immunities secured or protected by the constitutional laws of the United States. Okay, and so then they are individually, okay, they are subjecting you to the deprivation of your right to own consumer goods instead of business equipment, violating your rights under the color of law. They're subjecting you to the deprivation of your right to own consumer goods instead of business equipment. And then damage to religious property. Whoever intentionally obstructs by force or threat of force, including that threat of force against any person in the enjoyment of that person's free exercise of religious beliefs, or attempts to do so, shall be punished. Okay, and so again, if they are U.S. citizens and they're assaulting you with their satanic religious ceremony, and this is their good faith defense. Okay, and this is why it's taken forever for Barr to put together these indictments against these corrupt government officials, this deep state criminals like Schiff and Nadler and all these criminals. Anyways, the defense: a good faith reliance on a court warrant or order, a grand jury subpoena, a legislative authorization, or a statutory authorization, including a request of a governmental entity under Section 2703F of this title, a request of an investigative or law enforcement officer under Section 2518.7 of this title, or a good faith determination that Section 2511.3 of this title permitted the conduct complained of, is a complete defense to any civil or criminal action brought under this chapter or any other law. And that's 18 U.S.C. 2707. Now, this is good faith in Texas. No evidence, this sounds so nice in paragraph 1. No evidence obtained by any officer or any other person in violation of any provisions of the constitutional laws of the state of Texas or the constitutional laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Does that sound nice? Oh, that's so nice, yeah. And then paragraph B, it is an exception to the provisions of subsection A of this article that the evidence was obtained by a law enforcement officer acting in objective good faith, relying upon a warrant issued by a neutral magistrate based on probable cause. And so, again, but the government officials are required to know the law, okay? That remember, we talked about it, that they cannot issue a warrant, okay? So they know, they're supposed to know that a warrant can't be issued. So they can't claim good faith based on this because there's no warrant. Government officials are required to know that a warrant may not be issued. A capias may only be issued after they get jurisdiction to hold a trial and a conviction. And any denials of due process by the judge or bad behavior, they're always denied due process in countless ways. That's why I recommend you have one of my Kangaroo Court Survival laminated sheets with you in their so-called court. And it starts off with the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges both the Supreme and inferior court shall hold their offices during good behavior. And so, again, if they're not in good behavior, then they're in bad behavior. Okay, and if they're violating due process, then they're in bad behavior. And there is the laminated sheet, one side. Fraud upon the court is fraud which is directed to the judicial machinery itself. It's not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function. In other words, it's where the impartial functions of the court have been directly corrupted. And there's the other side of the Kangaroo Court laminated sheet. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Once challenged, jurisdiction cannot be assumed, it must be proved to exist. There is no discretion to ignore that lack of jurisdiction. Where jurisdiction is contested, a burden of establishing it rests upon the plaintiff. And again, we're talking, this is all about presumptions, and so they presume all sorts of stuff, and you have to be prepared. I would have a notice of appeal ready to go. The burden of proving jurisdiction rests upon the party asserting it. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. However late this objection to jurisdiction has been made or may be made in any cause in an inferior appellate court of the United States, it must be considered and decided before any court can move one step further in the cause, as any movement is necessarily the exercise of jurisdiction. A court has no jurisdiction to determine its own jurisdiction, for a basic issue in any case before a tribunal is its power to act, and a court must have the authority to decide that question in the first instance. A departure by a court of those recognized and established requirements of law, however close apparent adherence to mere form and methods of procedure which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. The burden shifts to the court to prove jurisdiction. The fact that the petitioner was released on a promise to appear before a magistrate for an arraignment, that fact is circumstance to be considered in determining whether in the first instance there was probable cause for the arrest. And so, again, if there's no probable cause, then everything else falls away. It is impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription up to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. When liberty and freedom at stake, your silence isn't golden, it's yellow. Where a court failed to observe safeguards, it amounts to denial of due process of law. Court is deprived of juris. Not every action by any judge is an exercise of judicial function. It is not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void and of no legal force and effect. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. That's Federal Rules of Civil Procedure. Defense of lack of jurisdiction over subject matter may be raised at any time, even on appeal. Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. And then in Texas, the county attorney has to represent the state in all cases in the district and inferior courts in their respective counties. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. In other words, if they don't have probable cause, then it's a malicious prosecution. A universal principle as old as law is that the proceedings of a court without jurisdiction are a nullity, and its judgment therein without effect either on person or property. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act or acts of treason. A court cannot confer jurisdiction where none existed, cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. Where there is no jurisdiction, there is no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Saya. And that's a federal court case citing Bradley versus Fisher, which is a U.S. Supreme Court case, and that's citing 10 Coke 68, which is 1500s. Brutum fulmen, an empty noise, an empty threat, a judge void upon its face, which is in legal effect no judgment of all, and by which no rights are divested, and from which none can be obtained, neither binds nor bars anyone. And that's Black's Law Dictionary. An officer who acts in violation of the Constitution ceases to represent the government. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. In arriving at our decision in this matter, we do not depart in any way from our holding in Hundling versus Jensen that the doctrine of judicial immunity extends to courts of limited jurisdiction, but when a minor magistrate acts wholly without jurisdiction, civil liability attaches for his malicious and corrupt abuse of process and his willful and malicious oppression of any person on the pretext of acting in his official capacity. And this is impersonating a public servant. Again, we already went over that. Change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change that we seek. So do not give them jurisdiction. Always make a special appearance. Point out their denials of due process. Do not allow them to enter a plea. It gives them jurisdiction. You're not entering a plea. I don't give you jurisdiction. You've already demonstrated that you're prejudged in this matter as a bought and paid for clerk for the prosecutor. So are we impersonating a judge today, are we? Demand that it be dismissed immediately. And that's the end. Okay, so they have a whole bunch of presumptions, and you got to understand what's going on and stand up to it. Okay, and have a notice of appeal ready to go. I don't care what it is. Okay, if it's a hearing and they want you to enter a plea, you don't enter a plea. And if they enter it for you, you tell you're not entering a plea for me. I don't give you permission. And if they go ahead and do it anyways, then here's my notice of appeal, and file a judicial complaint against the whore. Anyways, good luck, and keep me posted. Thanks for watching. Have a great day.